Okay, let's unpack this. Imagine a legal framework designed not just to uh, prevent unfairness, but to actively build a more equitable working world.
Yeah, a system that says, look, we're not just fixing past wrongs, we're proactively shaping a fairer future for everyone.
That's precisely what we're diving into today.
And what's fascinating here is that this isn't just, a set of rules. It's a really profound commitment to societal transformation.
Right.
We're talking about South Africa's Employment Equity Act of 1998, a foundational piece of legislation. And importantly, it's been updated quite recently, April 2025.
Okay.
So our mission in this deck dive is to really grasp its core purpose, understand its key provisions, especially those new changes,
Yeah.
explore the legal context that brought it to life, unpack its practical implications for, well, everyone, from employees to designated employers, and really highlight its real-world significance.
And whether you're maybe a law student grappling with these complex statutes or perhaps preparing for a crucial meeting, or honestly just someone curious about how laws actively promote equality and shape our daily working lives, this deep dive is for you.
Absolutely.
We're going to try and strip away the jargon, deliver those aha moments, make sure you walk away feeling informed, not overwhelmed.
Good plan.
So to truly appreciate the power of this act, we kind of need to understand its origins, right?
Yeah.
This wasn't just some random legal decree. It emerged from a very specific historical and societal need. The Act's own introduction, its preamble, it paints a clear picture.
It really does. And if we connect this to the bigger picture, the Act explicitly recognizes that the profound disadvantages created by the apartheid era and other discriminatory practices.
Well, they couldn't be fixed just by repealing old laws.
Right, that wasn't enough. Exactly. This deep dive is about understanding a proactive, a forward-looking approach. The core idea is to tackle those deep-seated disparities in employment, in occupation, income, right across the national labor market, to ensure a future where past discrimination doesn't keep casting a shadow,
Makes sense. So what's this act actually trying to achieve? You said it's ambitious.
Oh, incredibly ambitious. It goes way beyond just simple fairness. It's about knitting equality and true democracy into the very fabric of the workplace. It aims to eliminate unfair discrimination, actively rectify historical wrongs, and crucially, build a workforce that truly mirrors the diversity of the nation.
That's a big goal.
It is. And it even connects South Africa to global standards, aligning with International Labor Organization commitments, specifically Convention 111, on fighting discrimination. It's a holistic vision, really. It recognizes that economic development and workplace efficiency are deeply tied to this kind of equity.
And how does that holistic vision translate into how the law is actually interpreted and applied day to day?
Good question. The Act makes it crystal clear. It must always be read in compliance with the Constitution, always to give full effect to its overarching purpose, and always keeping those international obligations in mind.
So it's a powerful statement of intent.
Definitely. It ensures the spirit of the law, not just the letter, is constantly upheld.
Okay. Now, it's really important for you listening to know if this act applies to you. Whether you're an employee or an employer, it seems to have different layers of application, almost like a tiered system.
That's a great way to put it.
Yeah.
Yes. The Act is broadly divided into two main parts, two chapters, really.
Okay.
Chapter 2, the first part, focusing on prohibiting unfair discrimination. That applies to all employees and all employers. Big or small, doesn't matter.
So basic protections are universal.
Exactly. But then Chapter 3, the second part, which outlines affirmative action measures, that applies only to what we call designated employers and people from designated groups.
Okay.
And that distinction is absolutely vital for understanding who has what specific obligations and rights under the Act.
Right. So let's nail down these crucial terms then. Who actually falls under those heavier affirmative action duties, these designated employers?
Okay, good question. Think of them as generally the larger players in the economy or government bodies. As of January 1st, 2025, it's actually been simplified.
Oh, go.
It primarily means any employer with 50 or more employees. That's it. A clear, straightforward benchmark. They got rid of the previous criteria based on things like company turnover.
Simpler is usually better with law.
Usually, yes. It also includes municipalities and most organs of state. There are specific exclusions, though, like national defense or intelligence services for obvious reasons.
Okay, 50 plus employees, municipalities, state organs. Got it.
And
the designated groups.
right. This refers to Black people, women, and people with disabilities. The Act clarifies that Black people is a generic term encompassing Africans, coloreds, and Indians.
Okay.
And the definition of people with disabilities also saw an important update for January 1st, 2025.
What changed there?
It now includes those with a long-term or recurring physical, mental, intellectual, or sensory impairment, which, when interacting with various societal barriers, might substantially limit their employment prospects.
So it's a more inclusive definition.
Yeah.
More practical.
Exactly. It's focused on the interaction between the impairment and the barriers they face in the world of work.
Understanding these definitions really is like having the right map for this deep dive, isn't it?
Yeah.
Tells us who's navigating where and why those exclusions exist.
Precisely.
Okay, let's zoom in now. What does this mean for every single workplace?
Yeah.
Regardless of size. This is where the Act lays down the fundamental rules against discrimination.
Yes, this is Chapter 2. Every employer, absolutely every single one, has a duty to promote equal opportunity. And how? By eliminating unfair discrimination in any employment policy or practice.
Any policy or practice, that's broad.
It is. The core prohibition, Section 6, is really comprehensive. No person may unfairly discriminate, directly or indirectly, against an employee on a whole list of grounds. Race, gender, sex, pregnancy, marital status, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, political opinion, culture, language, birth. It's extensive.
Wow.
And here's where it gets really powerful. It also includes any other arbitrary ground.
What does that mean, arbitrary ground?
It means if you feel discriminated against for a reason that isn't on that specific list, but it feels unfair and totally unrelated to the job itself, the Act can still protect you. It's a safety net.
That's really significant. Are there exceptions?
Yes, common sense ones. It's not unfair discrimination to take affirmative action measures that align with the Act's purpose, obviously.
Right.
Nor is it discriminatory if a distinction is based purely on the inherent requirements of a job, like needing a driver's license to be a delivery driver.
Makes sense.
And beyond direct discrimination, harassment is also explicitly defined and prohibited as a form of unfair discrimination. And a really critical point, this was actually introduced back in a 2013 amendment, is the principle of equal pay for work of equal value.
Ah, yes. This is crucial.
It directly prohibits differences in pay or conditions based on discriminatory grounds like gender or race for employees performing the same work, or substantially the same work, or work that's actually of equal value, even if the jobs look different on the surface.
That's a powerful tool against the wage gap.
Absolutely. It's designed to be.
It's fascinating how detailed this Act gets. I mean, even things like medical and psychological testing stuff we often see as standard in hiring. They fall under intense scrutiny here.
Yeah, that's a great point because it really highlights the Act's commitment to rooting out even subtle forms of bias, right? On the surface, these tests might seem objective, neutral, but the law recognizes they have potential for discrimination. So, medical testing is generally prohibited unless it's specifically required by other legislation or it's genuinely justifiable based on medical facts, employment conditions, social policy, or, again, inherent job requirements. Testing for HIV status is even stricter. You actually need labor court justification for that.
Wow.
And as for psychometric tests or psychological assessments, they must be proven to be scientifically valid, reliable, applied fairly to all, and not biased against any employee or group. That point was even slightly refined in the 2025 updates, just underscoring how important it is.
And these protections aren't just for people already in the job, right? They extend to job applicants, too.
Yes, absolutely crucial. It fosters a fair starting line for everyone looking for work.
So this raises a really important question. What happens if you, as an employee or applicant, believe you've been unfairly discriminated against? What's the process?
Okay, think of it like different stages for trying to sort things out. For disputes other than unfair dismissal that's handled slightly differently, you can refer the matter to the CCMA.
The Commission for Conciliation, Mediation, and Arbitration.
Exactly. That national body for workplace disagreements. The first step is usually conciliation. A neutral person tries to help you and the employer talk it out, find a solution together.
Mediation, basically.
Sort of, yes. If that doesn't resolve it, it can escalate. It might go to the labor court for a formal adjudication, like a proper court case.
Okay.
Or in specific circumstances, like if the allegation is about sexual harassment Or if the employee earns below a certain threshold, the CCMA itself can conduct arbitration. That's like a less formal hearing where an independent commissioner hears both sides and makes a binding decision.
Right. And what about proving discrimination? That's often the hardest part.
This is where the Act does something really interesting, quite powerful. It flips the usual burden of proof.
How so?
In most legal cases, if you allege something, you have to prove it, right? The burden is on you.
Hmm.
But here, if you claim discrimination happened on one of those listed grounds, like race, gender, disability, the employer carries the burden. They have to prove that the discrimination didn't happen or that if it did, it was rational, fair, and justifiable under the Act's exception.
That's a huge shift.
It really is. It empowers the employee significantly. Only if the claim is based on one of those more unusual, arbitrary grounds does the person making the complaint have the initial burden to show there's a case to answer.
Okay, so that covers the universal anti-discrimination rules. But then for designated employers, the Act demands more, right? It goes beyond just not discriminating.
Exactly. This is Chapter 3. It demands proactive steps to achieve equity. This is where the concept of affirmative action really comes into play.
So what are those core duties for designated employers?
Okay, several key things. They must actively implement affirmative action measures for people from designated groups.
Yeah.
They have to consult properly with their employees about this.
Consultation is key.
Absolutely. Then conduct a thorough analysis, look at their employment policies, practices, procedures, and their workforce profile to identify any barriers or underrepresentation.
Find the problems.
Precisely. Then prepare and implement a proper written employment equity plan. And finally, they have to report annually on their progress to the Director General, the government official overseeing this.
Okay, let's unpack affirmative action measures. What does that actually mean in practice?
Good question. The Act defines them as measures designed to ensure that suitably qualified people from designated groups get equal employment opportunities and become equitably represented across all job levels.
So what kind of measures?
It includes things like identifying and eliminating employment barriers, maybe biased recruitment processes, promoting diversity actively, making reasonable accommodation for people from designated groups, especially people with disabilities,
Right.
and using numerical goals to improve representation where there are gaps. But, and this is crucial, the Act explicitly excludes quotas.
What's the difference? Numerical goals versus quotas.
A quota is generally seen as a rigid, mandatory number or percentage that must be filled, sometimes irrespective of whether candidates are suitably qualified. Numerical goals, as envisioned here, are targets that the employer sets, based on their analysis, to work towards achieving equitable representation over time. They need to be realistic and linked to the availability of suitably qualified people.
So it's a target, not a hard and fast must-fill number.
Exactly. And very importantly, the Act says these measures cannot establish an absolute barrier to the employment or advancement of people who are not from designated groups.
Okay. So it's trying to balance redress with fairness for everyone. That's often a point of debate, isn't it?
Yeah.
How does it strike that balance?
It's a delicate balance, absolutely. The Act is quite clear. While promoting representation for historically disadvantaged groups is the priority, it explicitly states these measures cannot create an absolute barrier for others. The focus is on equal opportunity for suitably qualified individuals.
Right.
It's about leveling the playing field so everyone gets a fair shot, while giving a necessary leg up to those previously held back by systemic discrimination. It's about inclusion, not exclusion.
Okay. Now, you mentioned things are changing, especially for next year. This is where it gets really interesting, right? A major development.
Yes, absolutely. Section 15A. This kicks in on January 1st, 2025, and it's a big shift.
What does it do?
The Minister of Employment and Labor now gets the power to identify specific national economic sectors. Think mining, finance, retail, whatever it might be.
Okay.
And then, after consulting properly with those sectors and the Commission for Employment Equity, the minister can actually set numerical targets for the representation of designated groups at all occupational levels within those specific sectors.
Wow. So targets set by the government, not just the employer.
Exactly. And these targets can be tailored. They might differ by job level or maybe by subsector or even by region.
That fundamentally changes the game for designated employers, doesn't it?
It really does. It moves from just internal employer-set goals towards a much more coordinated industry-wide approach driven by national equity priorities.
So the employment equity plan then becomes even more critical for designated employers. It's their roadmap.
It's absolutely their roadmap. It's not just a bureaucratic document. It's the active blueprint for achieving equity within their specific workplace.
What needs to be in that plan?
Okay, it has to state clear objectives, outline the specific affirmative action measures they'll use, and crucially, where they've identified underrepresentation, they must set numerical goals to achieve equitable representation for suitably qualified designated groups, level by level.
And these goals now have to align with.
From January 1st, 2025, yes, these employer-set numerical goals must comply with any relevant sectoral targets the minister has determined for their industry.
Okay. What else is in the plan?
It needs a timetable. How long will the plan run? Usually 1 to 5 years. Procedures for monitoring progress, evaluating success, and handling internal disputes related to the plan. And it has to assign responsibility to specific senior managers for actually implementing it.
You mentioned suitably qualified a few times. How does the Act define that? It's not just about degrees, is it?
No, absolutely not. And this is key. The Act takes a holistic view. Suitably qualified considers formal qualifications, yes, but also prior learning skills and knowledge gained outside formal education. Relevant experience is obviously important, but also, critically, the capacity to acquire the ability to do the job within a reasonable time.
So potential matters too.
Exactly. And the Act specifically says an employer cannot unfairly discriminate against someone solely on the grounds that they lack relevant experience, especially if they have the capacity to learn.
That's really important for opening doors.
It is. And for accountability, these designated employers have to submit annual reports to the Director General.
And these aren't just filed away.
No, they're public documents. If it's a public company, they have to publish a summary in their annual financial report. If it's a state organ, they table the report in Parliament.
So there's transparency.
Yes, transparency is crucial for public scrutiny and tracking whether real progress is being made.
Okay, so moving beyond just getting the job or getting promoted, does the Act address fairness within the job, particularly around pay? Income disparity is a huge issue for so many people.
Yes, it does. Section 27, which was also updated for 2025, tackles this directly.
Wow.
Every designated employer, when they submit their annual report, must also provide a statement on the remuneration and benefits paid at each occupational level. This goes to the National Minimum Wage Commission.
So another body gets involved.
Yes, acting as a watchdog. If that statement reveals disproportionate income differentials between different groups, or clear unfair discrimination in pay based on grounds like race or gender, linking back to that Section 6(4) equal pay principle,
What?
then the employer must take measures to progressively reduce those differentials. They have to show they're working on it, guided by advice from the minister and the NMWC.
And the NMWC's role.
They're specifically tasked with researching this, developing norms and benchmarks for what constitutes proportionate income differentials, essentially pushing for greater pay equity across the board.
Right. No law is effective without teeth, though. Without oversight and clear consequences. Who enforces all this?
Good point. The Act sets up strong oversight bodies. Chapter 4 establishes the Commission for Employment Equity.
Who do they do?
They advise the minister on things like codes of good practice, regulations, and overall policy direction. They conduct research, they can make awards recognizing employers who do well, and they can hold public hearings on equity issues. Their makeup is broad labor, business, state, community interests to ensure different perspectives are heard.
Okay, so they advise. Who does the day-to-day monitoring and enforcement?
That's primarily Chapter 5. First, employees and trade unions themselves can bring alleged contraventions to the attention of various parties, like labor inspectors or the Director General.
So employees have a direct role.
Yes. Then you have labor inspectors. They have significant powers.
Right.
They can enter workplaces, question people, inspect documents and records related to the Act. They can get written undertakings from designated employers to comply. Think of it like a formal promise to fix something. If that's not honored, the labor court can enforce it.
Okay.
Inspectors can also issue direct compliance orders if they find an employer isn't meeting specific duties, like failing to consult or do the analysis or keep proper records.
And if the employer ignores the compliance order?
Then the Director General can step in and apply to the labor court to make that order an official court order. They can also conduct broader reviews of an employer's compliance and make recommendations. Failure to comply with requests or recommendations during these reviews can also lead to the labor court getting involved, potentially imposing fines.
So this isn't just about gentle suggestions. There are serious legal consequences looming if employers don't take these obligations seriously.
Absolutely. The labor court has exclusive jurisdiction for interpreting and applying most aspects of the Act.
And what can the court order?
A wide range of things. It can make those compliance orders official court orders. It can award compensation or damages to an employee who suffered unfair discrimination. It can order the employer to take specific steps to prevent discrimination happening again.
Can it go further?
Yes. In serious cases, it could even order the removal of an employer's name from the designated employer register, which has huge implications, or order the publication of the court's decision, which is a significant reputational hit.
Wow. And the CCMA's role in enforcement.
They handle the conciliation, as we mentioned, and arbitration in certain cases,
Yeah.
like sexual harassment or for lower earners. CCMA commissioners can make appropriate awards within certain financial limits.
What about fines? Are they significant?
Oh, yes. The Act has a schedule outlining the maximum permissible fines, and they are substantial. Crucially, they escalate significantly for repeat contraventions.
Give us an example.
Okay, say an employer fails to prepare or implement their employment equity plan. First offense. The maximum fine could be around R$1.5 million. But if they've had 4 similar contraventions within the last 3 years, that maximum jumps to R$2.7 million, or 10% of the employer's annual turnover, whichever is greater.
10% of turnover, that's huge.
It's designed to be a serious deterrent. Plus, employers can also be held liable if one of their employees discriminates against another and the employer failed to take reasonable steps to prevent it. And there are specific, smaller fines for things like breaching confidentiality or obstructing an inspector.
And importantly, for anyone listening who might be worried about repercussions, employees are protected if they exercise their rights under this act, right?
Absolutely. Section 51 is very clear. No one can be discriminated against or victimized for exercising any right conferred by this act, like lodging a grievance or testifying in proceedings. That protection is vital.
Okay, so beyond the legal duties, the fines, the court cases, how does this act actually play out in the real world? What are the sort of immediate practical implications, especially for businesses wanting to work with the government? That seems like a big one.
It is a huge one, and Section 53, dealing with state contracts, has been significantly beefed up for 2025.
Okay, tell us about that.
Basically, any employer, designated or not, who wants to do business with any organ of state, supplying goods, services, renting property, they must comply with the relevant chapters of this act. Chapter 2 for everyone, Chapters 2 and 3 if they're a designated employer.
How do they prove compliance?
They need to provide a certificate of compliance issued by the minister, or at least a declaration stating they comply, which the Director General can then verify.
And what's the critical change for 2025?
The minister can now only issue that vital compliance certificate if the employer meets several conditions. First, if they are a designated employer subject to sectoral targets under Section 15A, they must have complied with those targets or provide reasonable grounds why they couldn't.
So those new targets are directly linked to state contracts.
Directly. Second, they must have submitted all their required EE reports. Third, they must have had no adverse findings of unfair discrimination against them by the CCMA or a court in the previous 12 months. And fourth, no adverse awards against them regarding compliance with the National Minimum Wage Act in the past 12 months either.
That's a high bar.
It is. And the kicker. Failure to comply with the act is now sufficient ground for the rejection of a bid or the cancellation of an existing state contract.
Wow. So compliance isn't just good practice, it's directly linked to economic opportunity, especially for businesses relying on government work.
Absolutely. It makes compliance a non-negotiable strategic imperative for many businesses.
Beyond the hard law, are there other resources to help employers?
Yes. The Act allows the minister, on advice from the Employment Equity Commission, to issue codes of good practice and regulations.
What are those like?
Think of them as practical how-to guides. They offer guidance on implementing the Act effectively, maybe, on how to prepare an equity plan, best practices for recruitment and selection to avoid bias, how to handle reasonable accommodation for disabilities, managing issues around family responsibility, preventing and dealing with harassment.
So, helpful tools.
Exactly. And importantly, the regulations also allow for simplified forms and procedures for smaller designated employers, those with fewer than 150 employees, to help ease the administrative burden for them, which is a practical consideration.
This deep dive offers so much more than just, reciting legal facts. It really feels like a powerful lens into how society actively tries to correct historical wrongs and build a better, more inclusive future for everyone.
It absolutely is. And if you think about who should care, for job seekers, understanding this act means knowing your rights against discrimination, knowing that employers, especially larger ones, must take active steps towards fairness. For employees already in a job, it clarifies your protections against unfair treatment, harassment, your right to equal pay for work of equal value, and it shows you the channels available if you need to raise concerns.
And for employers.
It's about grasping your legal duties, yes, but also recognizing the proven benefits of a diverse and equitable workforce innovation, better problem solving, wider talent pool, and of course, being acutely aware of the severe consequences of getting it wrong. Hefty fines, reputational damage, losing out on state contracts.
What about for law students listening?
Oh, it's a fantastic case study. You see constitutional principles like equality being directly translated into labor law. You see how administrative bodies like the CCMA and inspectorates work alongside the courts for enforcement. And you see how legislation isn't static, it evolves, like with these really impactful 2025 amendments trying to better meet societal needs.
And for the general public?
I think it's an appreciation of the ongoing, complex commitment South Africa has made to creating truly democratic and equitable workplaces. It helps understand the scale of the challenge inherited from the past and the specific, quite detailed tools the law provides to try and address it head on.
We've journeyed through this really intricate and, as you say, ever-evolving landscape of the Employment Equity Act. We've uncovered its profound purpose, trying to correct historical injustices, its comprehensive protections against discrimination for everyone, and its proactive measures, especially for designated employers, to build diverse and equitable workplaces. It really is a powerful testament to the ongoing pursuit of fairness in our society.
It really is. And maybe this raises a final thought, something for you to ponder as you reflect on this deep dive. As the Act continues to be refined, with amendments like these new sectoral targets, the stricter state contract conditions, what further role do you think individuals, employees, managers, leaders of organizations themselves should play? How do we make sure these legislative goals translate into true lived equality in every single workplace? How do we best navigate that complex balance between the absolute imperative of redress for past wrongs and ensuring fairness and recognition of individual merit for everyone? And maybe what will the truly equitable workplace actually look like a decade from now, shaped by these very provisions we've discussed today?